Good morning, students. Good morning and welcome to Unacademy. Welcome to the legal game, which is presented by Unacademy. I'm Sarthak Sharma. I'm going to be your legal reasoning expert at this platform, and I welcome you all to this wonderful platform that makes your learning easy, effective, efficient, and interesting. So let's start with today's class. And before starting, I would just like to switch on the live chat. So please wait for 2 minutes till the moment I switch on the live chats for a better interaction in our classes. Yeah. Yes, it's on my screen now. So today I'm going to discuss a brief intro, a brief overview about the law of torts. Law of torts is among the four major laws that is going to cover the majority of the syllabus in your law entrance examinations, whether it's the common law admission test, whether it's AILET, whether it's BLAT conducted by BHU. So in all these entrance examinations, there would be four major laws that would be asked. In addition to the miscellaneous laws that are the burning topic at the present, उनके अलावा कुछ four major laws हैं जो जरूर आते हैं. The first is the tort law, the second is the contract law, the third is the criminal law, and the fourth is the constitutional law. So today I'm going to give you a brief intro of the law of torts. And I know this thing that the law of torts is quite perplexing, is quite boring for a lot of students. बहुत सारे स्टूडेंट्स कहते हैं कि सर लॉ ऑफ टॉर्ट्स बहुत ही ज्यादा बोरिंग सब्जेक्ट है. इट सीम्स सो बोरिंग टू अस एंड दैट्स व्हाई टू मेक दिस सब्जेक्ट इंटरेस्टिंग as well as easy for all of you, I have come up with this session. It's my intention to make this particular topic interesting and easy for all of you, and I hope I would be successful till the end of this session. So stay with me and let's start with the class. Guys, before proceeding, let me give you a short intro of myself. I am Sarthak Sharma. And hi Muskan, good morning. Good morning. So I'm Sarthak Sharma. I'm a penultimate year law student at Faculty of Law, Jamia Millia Islamia. I have more than 2 years of teaching experience, and I've always said this thing that instead of years, I count days. Okay, so for me, each day count, and I will rather say that instead of 2 years, I have more than 700 days of teaching experience, and the days are still counting. That are still counting. I have mentored more than 10,000 students. For my students, I have been more of a companion and less of a teacher. मैं उनका साथी ज्यादा रहा हूँ, मैं उनका हमसफर ज्यादा रहा हूँ in this journey of their preparation. In the preparation journey, I have been their companion instead of a teacher. So I will rather say that I have been a companion to more than 10,000 students, and a lot of my students have been rankers in the prestigious law entrance examinations of this nation, like the common law admission test conducted by the Consortium of National Law Universities, the Symbiosis Law Admission Test, BHU's BLAT, then JMI LET, AILET, MHSET, and a lot more, like the Lucknow University, like CUCET. My students have been rankers. My companions have been rankers, I will say, and they have been laurels to us, to me, to their family, and yes, to their friends as well. So yes, I hope you all are also going to add your name in the list of the rankers produced by me. Moving forward, students, you can join me on Telegram. The Telegram link is on your screen. Just by accessing this link, accessing this link, you can join me on Telegram. The Telegram channel, the link of it is also available. The legal game. As I said, this channel is legal game presented by Unacademy, and the only motive of this particular platform is to boost up your preparation, to optimize your chances of cracking the target law entrance examination, whichever is it for you. Coming to the subscription of Unacademy. So students, you can subscribe to Unacademy either for the tenure of 24 months, for 18 months, for 9 months, for 6 months, for 3 months, or for 1 month. And you can have an additional discount not by using this ABC. Okay, you can use the code SRT10. The code is SRT10. That will give you an additional 10% discount. Means you can subscribe for 1, 3, 6, 9, 12, 18 or 24 months. Per month cost would be, for instance, for 24 months, the per month cost would be just 1400 per month. A total of 33,600, 1400 per month. And you can have an additional 10% discount by using the code SRT10. And this code is applicable for all the subscriptions. For 1 month to 24 months, you can use this code to subscribe to Unacademy for an additional 10% discount in addition to the regular discount. So go for the subscription, because subscription के बाद आपको Unacademy के इन unique features को के साथ मौका मिलेगा. You can, yeah, these six are among a lot more unique features of an academy. And if you want to avail these unique features, then the only doorway is the subscription of an academy. सिर्फ एक ही रास्ता है an academy के इन unique features को avail करने का. That is the subscription of an academy. Like you can just raise a hand and talk to the educator. I don't think that such unique features are available over any other platform. The only exception is an academy. So go for it. Go for the subscription. And moving forward, just on 22nd of October, today's date is 20th of October. Within 2 days, we are going to launch a rankers batch. This batch, the name is itself suggesting that the motive of this batch is to produce rankers. It's a 2-year comprehensive batch specifically for your CLAT 2023 preparation. See, CLAT 23 is almost 2 years away, and it's the perfect time to start your preparation now. Just like IIT and JEE class students, class 10th and 11th से ही IIT की preparation start कर देते हैं. Then remember guys, the national law universities are the IITs of law. Just like IITs are there in engineering, NLUs are there in law. So the national law universities are IITs law for law. So आपको IIT students की तरह ही preparation start करनी पड़ेगी from 2 years onwards, at least though from 2 years before. Okay, so 2023 के लिए it's a perfect time to start your preparation. You have 2 years in your, you have 2 years right now, and 2 years is a perfect time to start your preparation. It's an English medium batch going to be launched on 22nd of October, so you may enroll for it. And then yes, the live quiz feature for the students. What is this? So you can join the live quiz in just 3 easy steps. What you have to do, you just need to click on self study and navigate to tests. Guys, self study is the key to success. Remember, हम लोग तो आपको पढ़ा ही रहे हैं, but if you want to excel in the examination, then self study is something which is pervasive, which is applicable to every successful student. अगर सेल्फ स्टडी नहीं करेंगे तो फिर डिजायर्ड रिजल्ट्स नहीं मिलेंगे, चाहे आपको दुनिया का बेस्ट टीचर ही क्यों ना पढ़ाए. So you can click on the self study and navigate to test. You can click, then you have to click on live quiz, and you can either host a quiz. Yes, आप सिर्फ क्विज में पार्टिसिपेट ही नहीं कर सकते हैं, आप होस्ट भी कर सकते हैं. बिकॉज वी एट एन अकेडमी बिलीव दिस थिंग दैट नो वन नोज एवरीथिंग बट एवरीवन नोज समथिंग. हर इंसान सब कुछ नहीं जानता है, लेकिन हर कोई कुछ ना कुछ जरूर जानता है. दैट्स व्हाई वी हैव कम अप विद दिस यूनिक फीचर इन विच a student can not only participate in a quiz but he can also host a quiz. There might be chances कि मुस्कान आपको कॉन्स्टिट्यूशनल लॉ इतने अच्छे से आता हो जितने अच्छे से हम टीचर्स को या फिर ज्यादा स्टूडेंट्स को भी नहीं आता, बिकॉज यू हैव रिसर्च, you have deeply read this topic. Then you can host a quiz, you can create a quiz and host it, help your fellow mates. सिमिलरली बिकॉज ये सभी होता है कि हो सकता है किसी स्टूडेंट का फेवरेट सब्जेक्ट क्रिमिनल लॉ हो, उसको क्रिमिनल लॉ बहुत अच्छे से आता हो, एंड अनदर स्टूडेंट उसको लीगल करंट अफेयर्स बहुत अच्छे से आता हो, because he has worked on that particular thing. Then guys, definitely you can host the quiz, you can help your fellow mates. सबका साथ सबका विकास, I don't know इंडिया में हो रहा है नहीं, but an academy application पे it's perfectly working. So the special class features, as I have told you, these are the special class features of an academy. You can have interactive live classes, polls for learners. You can just raise a hand and you will never miss a class because this bell rings. ये जो घंटी है ये बजती है. Just download the Unacademy app, and once you will download, you will understand that this bell actually rings. Okay, so ये bell ring करेगी and it will notify you that the classes are due, that there is a class. Let's start with the topic today, introduction to law of torts. So as I always say that my prime motive through my classes is to convert your confusions into curiosity. I know that the biggest hindrance in a student's life, the biggest hindrance between success and a student is confusion. It is confusion. And what is my target? What is my aim? My aim is to convert your confusion. I will not clear your confusion. I will not kill your confusion. मैं confusion को खत्म नहीं करूंगा. I will convert your confusion into curiosity. What will I do? I will just convert your confusion into curiosity. Now how I will do it? देखिए, जिज्ञासा means curiosity is the key to success. Okay, behind every successful person, behind every intelligent person, there is curiosity in the mind. So जब भी हम कोई subject पढ़ेंगे, there are three questions which are the mother of curiosity, which are the root of curiosity. Whenever we are reading something, whenever we are thinking about something, or whenever we are doing something, तीन questions हमारे mind में जरूर आने चाहिए. What is this? Why I am doing this? And how to do it? So, what is the tort law? First of all, before proceeding with the class, I'm going to inform you कि इस class के end के बाद you will be able to answer these three questions. That what is tort law? Tort law है क्या? इसका जवाब आप मुझे खुद देंगे at the end of this session. Why we study tort law? इसका आंसर भी I will ask you in the end of this class, and you will tell me that why we study tort law. And the third question, that how to study tort law, कैसे पढ़ा जाए, what is the best strategy to study it, इसका आंसर भी आप लोग खुद देंगे. I promise you that you will answer it. All right, so these are the three questions that we are going to find. These are the three questions of which we are going to find answer in today's class. ये वो तीन सवाल हैं जिनका जवाब हम आज की क्लास में ढूंढने की कोशिश करेंगे. What is tort law? Why we study tort law in India? And how to study tort law? Let's start with the class now. So let me give you a basic overview first of all about this, the branch of tort law. So the first of all, this word torts is not an English word, it's a French word, and the root of tort is the Latin word tortrum. Okay, what is the root of the word tort? The root is Latin word tortrum. Now, what is this Latin language? Similarly, Latin is the Sanskrit language of the British, as you may say. India में Sanskrit language है. All the words of Hindi, the Hindi language and the Urdu language, they have been derived from the Sanskrit language. Sanskrit is the mother of English and Urdu. I hope you know. Like आप कोई भी हिंदी का वर्ड पकड़ लीजिए, उसका रूट आपको संस्कृत से मिलेगा. Let me give you an example. पशु, जानवर को हम पशु क्यों कहते हैं? बिकॉज इन संस्कृत रस्सी का मतलब होता है पाश. सो जिसको रस्सी से बांधा जाए वो पशु. इट्स अ हिंदी वर्ड. अनदर थिंग, भूमिजा, एक बीच को हम भूमिजा कहते हैं. ओके, बिकॉज इन संस्कृत भूमिज मीन जमीन, और जो जमीन से पैदा होता है वो भूमिजा. सिमिलरली इन लैटिन लैंग्वेज इफ देयर इज अ वर्ड, देन इंग्लिश में वो जो वर्ड होगा उसका रूट लैटिन में ही होगा. लेट मी गिव एन एग्जांपल. देयर इज अ मैक्सिम इन of principles of natural justice, odi alteram partem. Odi alteram partem. What does odi means? Odi is a Latin word which means to hear, सुनना. You can connect. Odi से ही एक English word निकल के आया बहुत ही famous, audio. Audio means something which we hear. हम सुनते हैं. So odi means to hear. Let me give you one more example. Like Lex Loki. Loki means place. Loki is a Latin word. Loki से भी एक English word बहुत famous निकल के आया है, which is location. Location means place. So Latin is the mother of English language, and all the languages, most of the languages which are used in the Europe, okay, in the United Kingdom, like French, like Greek, all right, like Italian. Latin is the mother of all these languages. Latin is the Sanskrit of British, as you may say, the Sanskrit of Europe. So Latin language का एक word है tortrum, which means to twist. So simply, and in French, literally, this word tort means a wrong, a twisted act. देखिए, क्या जो एक इंसान बहुत सीधा साधा उसे बोलते हैं दैट ये सीधा साधा इंसान है, और जो गलत काम करता है ये टेढ़े काम करता है. टेढ़े काम मतलब twisted works. Okay, so tortrum means to twist. I hope you got it. That what does tortrum means? To twist, a twisted act, okay, or a wrongful act. So what is a tort? A tort is simply a wrongful act. The meaning of tort is a wrongful act. And what is it? Let me give you a nature of tort law. It is a civil wrong. Tort is a civil wrong. Civil wrong means private wrong. So, and one more important thing, read it, that tort is a civil wrong that is not breach of contract or breach of trust. It means torts give a negative definition. How will I say that who is a foreigner? Foreigner is any person who is not an Indian is a foreigner for us. Any person who is not an Indian is a foreigner. मतलब हम देखेंगे कि कौन कौन इंडियन है, जो भी इंडियन नहीं है वो फॉरनर है. इट इज अ नेगेटिव डेफिनेशन. सिंपली व्हाट इज अ टॉर्ट लॉ? Tort law is a civil wrong which is not a breach of contract or breach of trust. पहले हम देखेंगे कि वो wrong civil है या criminal है. If it is a civil wrong, then we will identify that whether it's a breach of contract or breach of trust. If it is not breach of contract or breach of trust, then it is a tort. All right. So the biggest nature of tort law जो हमें अब तक पता लगा that it is a negative. It gives a negative definition. And guys, remember, in any common law country like India, tort law is very important. Now, what is a common law country? वो सब देश जिन पर ब्रिटिशर्स ने रूल किया है, all those nations where there have been colonization, हम उन्हें common law nations कहते हैं. I hope you might have heard about the Commonwealth Games. कॉमनवेल्थ गेम्स में कौन से देश पार्टिसिपेट करते हैं? डज यूनाइटेड स्टेट्स ऑफ अमेरिका पार्टिसिपेट इन कॉमनवेल्थ? नो. डज जापान पार्टिसिपेट्स इन कॉमनवेल्थ? नो. डज चाइना पार्टिसिपेट इन कॉमनवेल्थ? नो. कॉमनवेल्थ गेम्स में पार्टिसिपेट करता है इंडिया, पाकिस्तान, अफगानिस्तान, साउथ अफ्रीका, ऑस्ट्रेलिया. मींस ऑल द नेशंस ओवर व्हिच देयर हैज बीन अ ब्रिटिश रूल. कॉमनवेल्थ ऑफ नेशंस एक ग्रुप बनाया गया और उसमें वो सब देश हैं जिनकी वेल्थ एक कॉमन देश ने लूटी. मींस दिस इट्स जस्ट माय थिंकिंग कि शायद ये नाम रखा, इसलिए नाम रखा होगा, ऑल्दो इट्स नॉट क्लियरली मेंशन्ड दैट कॉमनवेल्थ नाम रखने के पीछे का ये रीजन था, बट यू कैन अंडरस्टैंड लाइक दिस दैट कॉमनवेल्थ ऑफ नेशंस मींस दैट ग्रुप जिस ग्रुप की वेल्थ एक कॉमन देश ने लूटी. ब्रिटिशर्स ऑब्वियसली इंडिया की भी बहुत सारी वेल्थ लूट कर गए. So India is a common law country because most of the laws in India are inspired from Britishers. Most of the laws in India are pre-constitutional laws. Constitution के आने से पहले से ही थे. Indian Penal Code 1860, Indian Contract Act 1872, Indian Evidence Act again 1872. All these laws are from 1800. CPC 1908. All the laws are pre-constitutional, made by Britishers. Most of the laws. So, as I gave you a basic overview, a wrong can be of two types. एक wrong दो तरह का हो सकता है. A wrong that affects the society, which is a public wrong. Okay, a wrong can be a public wrong. Public wrong is also known as crime because it affects the society at large. And a wrong can be a private wrong, which affects only a private individual or a group of individual. It's a private wrong. Okay. Now, a private wrong is known as civil wrong and a public wrong is known as crime. Okay. And why a public wrong is known as crime? Because it affects the society. मैंने आपको बताया था कि wrong दो तरह के होते हैं, a public wrong and a private wrong. A public wrong is crime which is dealt in Indian Penal Code in CRPC. All right. And public wrong affects the society at large. Means होता ये भी एक private individual के ही against है, बट ये सोसाइटी को अफेक्ट करता है. इट शूक्स द कंसाइंस ऑफ द सोसाइटी. लाइक निर्भया रेप केस हुआ, पूरी सोसाइटी शॉक हो गई. सो द सोसाइटी इन अ पब्लिक रॉन्ग, द सोसाइटी डिसाइड्स टू पनिश द रॉन्ग डूअर, कि हम रॉन्ग डूअर को पनिश करेंगे. अब जंगल राज तो है नहीं कि अगर किसी ने क्राइम किया तो सब लोग मिलकर उसको मारेंगे. इट इज नॉट. वी हैव अ क्रिमिनल जस्टिस सिस्टम. सो हु इज द रिप्रेजेंटेटिव ऑफ द सोसाइटी? रिप्रेजेंटेटिव ऑफ द सोसाइटी इज द गवर्नमेंट, जिनको हमने वोट देकर पार्लियामेंट में बिठाया है. एंड दैट्स व्हाई इन क्रिमिनल केसेस इज ऑलवेज अगेन स्टेट वर्सेस द अक्यूज्ड. क्रिमिनल केसेस को हमेशा स्टेट प्रोसिक्यूट करती है अगेंस्ट द अक्यूज्ड. इफ द क्राइम हैड बीन कमिटेड इन उत्तर प्रदेश, देन स्टेट ऑफ यूपी वर्सेस अक्यूज्ड. इन पंजाब, देन स्टेट ऑफ पंजाब वर्सेस अक्यूज्ड. इन हरियाणा, देन स्टेट ऑफ हरियाणा वर्सेस अक्यूज्ड. Clear? So in a crime is a public wrong in which the conscience of the society is shocked, and that's why the representatives of the society, which is the government, the state, prosecutes the wrongdoer. State versus accused के नेम से होते हैं. But in private wrong, the society is not shocked. All right, it is just a private act in which एक particular individual या फिर एक group का कोई right violate हुआ है, and they can claim for compensation. So civil wrongs हमेशा A versus B में होते हैं. One individual versus another individual, plaintiff versus defendant. Now here you need to note one thing. In criminal cases, state is always the prosecutor and can never be the accused. State crime नहीं कर सकती और हमेशा criminal के against prosecution state ही करेगी. Private individual नहीं कर सकता. All right. There is one exception, the compoundable offenses. I will teach you later on in criminal law. But right now, you just need to understand that in criminal cases, state is always the prosecutor and never the defendant. The cases would be always state versus accused. State कभी भी accused नहीं हो सकती है. State is always the prosecutor. But in civil cases, either state can be none of the party or state can be either of the parties. हो सकता है स्टेट प्लेंटिफ हो सकता है स्टेट डिफेंडेंट हो, और हो सकता है स्टेट दोनों ही ना हो. बिकॉज इन दिस, in civil cases, there is no accused, there is just plaintiff and defendant. Let me give you an example. But here also state would be in its personal capacity. Reliance Industries and UP government के बीच एक contract हुआ, and then there was a breach in that contract. It is a, there would be a civil case. Reliance Industry ने breach कर दिया. Then the UP government uh, filed a case, a civil case of compensation against Reliance Industries. The name of the case would be State of UP versus Reliance Industries. But it is not a criminal case. It is a civil case because state is not here in the capacity of representative of the society, but in its private capacity, in its personal capacity. Clear? So that's the basic thing that you need to understand. That in a civil wrong, स्टेट हो सकता है प्लेंटिफ हो, स्टेट हो सकता है डिफेंडेंट भी, और स्टेट हो सकता है दोनों ही ना हो. The case can be in format of A versus B, in which state can be A means plaintiff or B means defendant, or can be none of the two. But here the state would be in its personal capacity, not in its capacity as the representative of the society. So coming to civil wrong, a civil wrong can be of three types. It can be a breach of contract. ब्रीच ऑफ कॉन्ट्रैक्ट जो आप लोग कॉन्ट्रैक्ट लॉ में डील कर चुके हैं. आई हैव ऑलरेडी टेकन अ क्लास ऑन इंट्रोडक्शन ऑफ लॉ ऑफ कॉन्ट्रैक्ट्स एट द अनअकैडमी प्लेटफॉर्म. यू कैन गो एंड वॉच दैट क्लास. ऑल राइट, अनअकैडमी प्लेटफॉर्म पे इंडियन कॉन्ट्रैक्ट एक्ट के इंट्रोडक्शन के ऊपर आई हैव अ क्लास. इट कैन बी टॉट एंड इट कैन बी ब्रीच ऑफ ट्रस्ट. एंड व्हाट इज द डेफिनेशन ऑफ टॉट? एनी सिविल रॉन्ग मींस सबसे पहले रॉन्ग होगा, उस रॉन्ग को हम आइडेंटिफाई करेंगे दैट वेदर इट्स अ क्राइम और सिविल रॉन्ग. इफ इट इज अ सिविल रॉन्ग, then any civil wrong which is not a breach of contract, which is not a breach of contract and not a breach of trust, is a tort. जो भी breach of contract या breach of trust नहीं है वो tort है. It means tort gives a negative definition. What is the reason that it gives a negative definition? See, if we try to confine the concept of tort in a single straitjacket definition, it's absolutely false. We cannot do it. We will definitely be unsuccessful in it. Why? Because tort law is uncodified as well. Uncodified means it is not written anywhere. There is no particular statute जिसमें tort law लिखा हुआ है. Tort law is constantly evolving in the court of laws. जो हमारी कोर्ट्स हैं वो tort law को इवॉल्व कर रही हैं. इंग्लिश कोर्ट्स ने tort law को स्टार्ट किया था. That's why it gives a negative definition. Just like I give you the example of foreigner. A foreigner can be from England, from USA, from Australia, from Ireland, कहीं से भी हो सकता है. So how will I say that who is a foreigner for us? Any person who is not an Indian is a foreigner. कोई भी इंसान जो इंडियन नहीं है फॉरेनर है, वो कोई भी हो सकता है. He can be anyone, but he should not be an Indian. Similarly, any civil wrong can be a tort, but it should not be a breach of contract or breach of trust. I hope everything is clear till here. If any student has any doubt, they can ask me in the live chat. All right, and remember, tort law USA में नहीं है, tort law जापान में नहीं है, tort law इंडिया में है because India is a common law nation. Okay, tort law is only in India because we are a common law nation. We are a common law system, and a common law system is in every country which was under the British Empire. Any country which was under the British Empire has a common law system. It is clear? I hope it is. So, all right, guys, remember this thing that in every common law system, tort law is there. Tort law कहाँ होता है? हर एक common law system में होता है. Okay, so let's move forward. It is clear that what are common law nations? Those nations over which there had been colonization. मैंने आपको easiest example याद करने के लिए बताया Commonwealth of Nations. Commonwealth of Nations are those nations that have been under the British Empire. Moving forward, you have a basic overview of tort law. You know that tort law, what is tort law? Tort law is a civil wrong which is not a breach of contract or breach of trust. And from here, you got to know two natures of tort. The first nature is, first of all, understand that a person who commits a tort is called tortfeasor. A person who commits a crime or who is accused of committing a crime is called offender or accused. Similarly, a person who commits a tort is called tortfeasor. A person who commits a tort is called tortfeasor. Moving forward, the tort is the only law, as I told you कि tort unwritten law है. Tort is the only law which is uncodified. Uncodified means unwritten. It is the only branch of law which is unwritten. What does unwritten means? Unwritten means it is not written anywhere. ये क्यों नहीं लिखा है? There is no statute, there is no act of legislation, which is there is no act of statute, there is no legislation in which the tort law is written. कहीं नहीं लिखा है. It is an unwritten law and it is derived from the decisions of House of Lords. Majority of the tort laws are derived from House of Lords means the courts of England. कोर्ट्स ऑफ इंग्लैंड इंग्लैंड में कोर्ट्स को हाउस ऑफ लॉर्ड्स कहा जाता था लेट मी गिव यू अ वेरी इजी एग्जांपल आई होप आप सभी ने टॉर्ट लॉ के बेसिक्स पढ़ने स्टार्ट कर दिए होंगे यू माइट हैव हर्ड अबाउट द स्ट्रिक्ट लायबिलिटी इमर्ज्ड फ्रॉम राइलैंड्स वर्सेस फ्लेचर इट्स अ केस हाउस ऑफ लॉर्ड्स ने इमर्ज किया एब्सोल्यूट लायबिलिटी तो इंडिया ने ही दी यार टॉर्ट लॉ के जुरिस्प्रूडेंस को इंडिया इन द केस ऑफ एमसी मेहता वर्सेस यूनियन ऑफ इंडिया द भोपाल गैस लीक केस एंड द श्रीराम फर्टिलाइजर्स गैस लीक केस इन दोज गैस लीक केस इंडियन सुप्रीम कोर्ट इवॉल्व द प्रिंसिपल ऑफ एब्सोल्यूट लायबिलिटी किसने इवॉल्व किया पार्लियामेंट ने नहीं कोर्ट ने बिकॉज कोर्ट इज इवॉल्विंग दीज प्रिंसिपल्स इन देयर जजमेंट दैट्स व्हाई द branch of tort law is uncodified that is unwritten it is not written anywhere and because it is unwritten that's why it is cannot be confined into a particular boundary कोई boundary है ही नहीं जब भी कोई मिसलेनियस रॉन्ग सिविल रॉन्ग होता है जब भी कोई मिसलेनियस सिविल रॉन्ग होता है तो वो टॉर्ट्स के अंडर आता है ऑल राइट बिकॉज वी नो व्हाट इज अ ब्रीच ऑफ कॉन्ट्रैक्ट एनी a breach of contract is something which is defined in Indian Contract Act. A breach of trust is something which is defined in Indian Trust Act. And what can be a tort? Nowhere written. That's why any miscellaneous civil wrong is a tort. कोई भी एक नया तरह का सिविल रॉन्ग हो गया फर्स्ट टाइम हुआ अब वो किस ब्रांच में आएगा कॉन्ट्रैक्ट में नहीं आ सकता टॉर्ट में नहीं आ सकता कॉन्ट्रैक्ट एंड ट्रस्ट में नहीं आ सकता देन वो टॉर्ट में आएगा ऑल राइट सो दैट्स व्हाई द टॉर्ट इज बाउंड्रीलेस एंड द थर्ड इंग्रेडिएंट whenever a legal right vested in a property अब ये भी आपको समझ में आ गया that there shall be a legal right which is vested in a property when this legal right is violated by someone's act or omission tort is committed there shall be a legal right which is violated and due to that and that legal right has been violated by a person's action or omission why omission as well for instance a person has a duty of care and he breached that duty like in negligence there has been an omission of the duty of care due to which tort is committed clear so tort gives a negative definition tort is uncodified that is unwritten all right and it is followed in common law countries ये तीन आपके सबसे बेसिक फीचर्स हैं नेचर है टॉर्ट लॉ के okay tort is an important branch of law in common law country like India you know what is a common law country any nation over which Britishers have ruled because Britishers ने जहां राज किया है वहां अपने अपने लॉ को भी छोड़कर गए हैं like in India the majority of the important laws are pre-constitutional pre-constitutional means the laws that were made by the Britishers these laws were not made by India okay Indian Contract Act Britishers ने बनाया IPC Britishers ने बनाया इंडियन एविडेंस एक्ट ब्रिटिशर्स ने बनाया इंडियन ईजमेंट एक्ट ब्रिटिशर्स ने बनाया ऑलराइट सो tort is an important branch of law in common law countries like India but not in the foreign nations clear let's move forward let's come to the essentials of tort now I hope everything is clear till now if you have any doubt you can raise it in the live chat I will be more than happy to answer them all right but if you are clear then we shall move forward we will go slowly but steadily we know that रैबिट्स रेस नहीं जीतते हैं टॉर्टोइज ही जीतते हैं बचपन से ही वो कहानी सुनाई जा रही है बिकॉज टॉर्टोइज आर कंसिस्टेंट इट द मॉरल ऑफ द स्टोरी ऑफ दैट रैबिट एंड टॉर्टोइज वाज व्हाट कि हमको जल्दबाजी नहीं करनी है कहते हैं जल्दी का काम शैतान का होता है और जीतता वही है जो कंसिस्टेंस है कंसिस्टेंसी विंस द रेस ऑल राइट वो जो कछुए और खरगोश की हमें कहानी सुनाई गई थी वो इसलिए नहीं सुनाई गई थी कि तेज भागना गलत है तेज भागो तो भी कंसिस्टेंसी के साथ भागो एंड दैट्स व्हाई इट इज सेड दैट स्लो एंड स्टेडी विंस द रेस we will obviously be not very fast we will not be slow as well but we will be consistent all right you have no doubt till now then let's start with the essentials of tort what are the essential elements of tort so there are only two essential elements first is injuria means legal injury what you can call this लीगल इंजरी मतलब इंजुरिया को हम क्या बोल सकते हैं? अ वॉयलेशन ऑफ अ लीगल राइट, वॉयलेशन ऑफ अ लीगल राइट, whenever a legal right is violated, tort is committed. लीगल राइट का वायलेट होना बहुत ज्यादा जरूरी है. द फर्स्ट एसेंशियल इज इंजुरिया विच इज वायलेशन ऑफ अ लीगल राइट. ऑल राइट, देयर शैल बी इंजुरिया. अच्छा, लीगल राइट वायलेट होना चाहिए और क्या होना चाहिए? These essential elements of torts means ingredients which should be there in a tort. Essential elements of torts, or you may say essential ingredients of torts. These things should be present in an act. तभी वो एक्ट एक actionable tort होगा. Now, what is an actionable tort? An actionable tort is one for which you can go to the court and claim compensation. Inactionable tort in which you cannot go to the court. It is not a tort at all. Actionable means जिसमें कोर्ट में केस फाइल हो सकता है. Inactionable means there can be no case in the court. कोर्ट में कोई केस फाइल नहीं हो सकता. All right. So, injuria is legal injury. Legal injury simply means violation of a legal right. There shall be a legal right which has been violated either by an act or an omission, either by an action or by an omission. Another ingredient is a wrongful act or omission, as I said. अब ये लीगल इंजरी कैसे वॉयलेट होगी? अपने आप थोड़ी. मींस मैं मेरा लीगल राइट है वोट देने का और मैं अपनी मर्जी से ही वोट देने नहीं गया, फिर मैं कहूं कि मेरा लीगल राइट वॉयलेट हो गया? इज इट? नो. किसी दूसरे इंसान के एक्शन या ओमिशन से लीगल राइट वॉयलेट होना चाहिए. Okay, there should be a wrongful act or omission. A person should have duty of care which he has breached. Duty of care. All right, and there shall be a legal remedy available. उस legal injuria की legal remedy भी available होनी चाहिए. Legal remedy under law is known as damages, not damage. Damage means नुकसान and damages means, what does damages means? Damages means, okay, the damages means a law compensation. Okay, damages stands for compensation. All right. So damage means loss and damages means compensation. So there shall be a legal remedy means there shall be damages available. अगर उस लीगल इंजरी की कोई कंपेंसेशन ही अवेलेबल नहीं है. रिमेंबर, इन टॉर्ट लॉ द damages are unliquidated. In contract law damages are liquidated. Unliquidated means not decided beforehand. कॉन्ट्रैक्ट लॉ में बिफोर हैंड डिसाइडेड होते हैं. इफ ए एंड बी एंटर्स इनटू अ कॉन्ट्रैक्ट, देन उस कॉन्ट्रैक्ट में एक क्लॉज होता है. इन मेजॉरिटी ऑफ टाइम्स देयर इज अ क्लॉज दैट इन केस ऑफ ब्रीच ऑफ कॉन्ट्रैक्ट बाय ईदर ऑफ द पार्टीज, this amount of compensation would be paid by the breacher to the party. All right, I hope I am audible. Okay, so guys, you got it, that legal in the damages, that is the compensation in tort law, is unliquidated. It is the nature of damages. Unliquidated means not pre-decided. पहले से decided नहीं होता क्योंकि पहले से पता ही नहीं होता कितना नुकसान होने वाला है. But in contract law the damages are liquidated. What are liquidated? Pre-decided. Like A and B enter into a contract, तो contract में ही clause होता है कि in case of breach of contract this much amount of compensation would be paid by the party who breached the contract to the party against whom the contract had been breached. So there is liquidated damages in contract, but in tort law there is no such contract. That's why there is unliquidated damages always. Remember a question आ चुका है that what is the nature of damages in tort law? Unliquidated. Reason भी आपको समझ में आ गया है. Moving forward, one more thing that you need to remember, yes, there are two types of right. If there is a legal right that had been violated, किस तरह का right violate हुआ है? There are two types of right. First is right in rem. Okay, right in rem. And then there is one more type of right, which is right in personam. Okay, and then there is right in personam. So in tort law, which type of right is there which is violated? Right in rem or right in personam? कोई बता सकता है? इन कॉन्ट्रैक्ट लॉ देयर इज राइट इन पर्सोनम. राइट इन पर्सोनम मीन्स अ राइट which is available only against a particular person, a particular private individual. Like I entered into a contract to purchase a car from B. Then I have a right to take the car from B, and B has a right to take the amount of the car, for instance 5 lakh rupees from me. अब ये right मुझ पे किसी सिर्फ B के towards है, किसी थर्ड इंडिविजुअल के टुवर्ड्स नहीं. टू टेक द डिलीवरी ऑफ द कार, ये राइट मेरे पास बी के टुवर्ड्स है, नॉट टुवर्ड्स सी डी ई और एनी अदर इंडिविजुअल ऑफ द सोसाइटी. सिमिलरली बी के पास जो 5 लाख रुपीज लेने का राइट है वो सिर्फ मेरे टुवर्ड्स है, मेरे अगेंस्ट है, ना कि किसी दूसरे इंसान के अगेंस्ट. इट इज कॉल्ड राइट इन पर्सोनम व्हेन योर राइट इज ओनली अगेंस्ट अ पर्टिकुलर प्राइवेट इंडिविजुअल. बट टॉर्ट लॉ में राइट इन पर्सोनम नहीं होता है, टॉर्ट लॉ में राइट इन रेम होता है. नाउ व्हाट इज राइट इन रेम? A right in rem is a right which is available towards against any individual from the society. Like I have a right not to be injured. मेरा एक राइट है कि मेरी बॉडी को कोई चोट नहीं पहुंचाएगा, नॉट टू बी बॉडीली हार्म्ड. इट इज अ राइट इन रैम. वाई इट इज अ राइट इन रैम? क्योंकि ये राइट सिर्फ ए बी या सी के टुवर्ड्स नहीं है. दिस राइट, आई हैव दिस राइट अगेंस्ट एवरी पर्सन फ्रॉम दिस सोसाइटी. कोई भी मुझे चोट नहीं पहुंचा सकता. इफ समवन इंजर्स मी, ही would be violating my legal right because it is a right in rem. So remember, this question has also been asked in your examination a lot of time, that what type of right is there in the tort law? Right in rem. And what type of right is there in contract law? Right in personam. Right in personam towards a particular individual. Okay, note this thing down. Right in personam towards a particular private individual. सिर्फ एक पर्टिकुलर इंडिविजुअल के टुवर्ड्स होता है. And right in rem towards any, against any person from the society, any individual, towards a particular individual and towards any individual. Okay, let me write it. Any individual. All right, I'm not able to write. I hope you have write it down. So please take a pen and a copy with you, because okay, right in rem is against any individual and right in personam is against a private individual. Let's move forward now. Okay, students, let's move forward. Yes, we were here. Now it's all right. So we have already discussed the elements of tort, injuria, wrongful act, and a legal remedy. Moving forward, the two foundational principles of tort law. Yes, the two maxims. अब tort law के जो foundational principles हैं, what are those foundational principles in a law, in the law of torts? Means the maxims जो law of torts की पूरी branch का founding stone है. These are the foundation, जो ये नींव है tort law की पूरी branch की. There are only two important legal maxims. और भी बहुत सारे हैं, but these two are the most important. These two are the foundational principles of tort law. Okay, so let's discuss them. The first one is injuria sine damnum. What is injuria sine damnum? You just read about the essentials of a tort. एसेंशियल्स ऑफ टॉर्ट आपने पढ़े, जिसमें इंजुरिया सबसे पहले था. व्हाट डज इंजुरिया मींस? यू जस्ट नोटिस्ड इंजुरिया मींस अ लीगल इंजरी. अ लीगल इंजरी. लीगल इंजरी इज वायलेशन ऑफ अ लीगल राइट. whenever a legal right is violated, there is injuria. What does sine means? Sine is a Latin word which means without. And what does damnum means? Damnum means damage, not damages. Damnum doesn't means damages, it means damage. Okay, what does damnum means? It means damage. Damage means loss. Damages means compensation for the loss. Damage means loss and damages means compensation for the loss. So injuria sine damnum means a legal injury without damage, a violation of legal right without any damage or loss. Let me give you a very easy example, but before, understand that injuria sine damnum are actionable torts. The cases of injuria sine damnum are actionable torts. Means If there is a case of injurious and damnum, you can go to the court of law and demand for compensation. Injurious and damnum means there had been a legal injury, a legal right has been violated, but without any damage. Damage नहीं हुआ. इजी एग्जांपल मैं आपको देता हूं एंड इट्स फैक्ट्स ऑफ अ रियल टॉर्ट लॉ केस एशबी वर्सेस वाइट जिसमें द पिटिशनर वेंट वाज एन एलिजिबल वोटर इन द वोटिंग लिस्ट और ही वाज गोइंग टू वोट फॉर द कैंडिडेट ओके बट उसको बी ने वोट देने से रोक लिया ही वाज स्टॉप्ड इन बिटवीन एंड उसकी वजह से ए अपने कैंडिडेट को वोट नहीं दे पाया लेटर ऑन द रिजल्ट्स ऑफ द इलेक्शन केम एंड इलेक्शन में वही कैंडिडेट जीता जिसको ए वोट देकर जिताना चाहता था बट देन ऑल्सो ए वेंट टू द कोर्ट एंड फाइल्ड अ केस अगेंस्ट द पिटिशनर एंड द कोर्ट प्रोवाइडेड कंपेंसेशन it is a classic case of injurious and damnum there had been legal injury there was a legal right to vote which has been violated but there is no damage क्योंकि वोट देकर भी वो जिसको जिताना चाहता था वो तो जीत ही गया so there is no damage but there is a legal injury so this is a classic example of injurious and damnum so आपको एक actionable tort में क्या find out करना है a legal injury if there is a legal injury means violation of a legal right then it's an actionable tort otherwise it would be inactionable tort clear there is one more legal maxim just injurious and damnum को हम opposite करके उल्टा करके पढ़ते हैं damnum you know what is damnum is damage or loss sign is without a legal injury means without a violation of legal right what is this okay Raj sir please tell the schedule of classes Raj I will take the classes at 8 a.m. in the morning and 9 p.m. in the evening that would be the class for me that would be the schedule for me for all the days मैं सुबह 8 बजे और रात को 9 बजे आपसे मिलूंगा इसी प्लेटफॉर्म पे and you can also attend my classes on the application Unacademy application pe I have taken the classes on introduction of contract law, introduction of criminal law and article 370 के ऊपर on the Ayodhya judgment. I have taken a lot of classes over that platform. So you can attend there as well. Rishabh is asking sir MHSET में 120 to 125 marks पर कौन सा कॉलेज मिलने का चांसेस है ऋषभ let's wait for the cutoff but I think you have a fair chances of getting the top 5 colleges. Let's hope for the best because MHSET का पेपर इस बार बहुत ही easy था. So coming to the class, yes, damnum sign injuria is a damage without a legal injury. Now what does this stands for? कि नुकसान तो हुआ है लेकिन लीगल राइट वॉलेट नहीं हुआ इसका भी मैं आपको एग्जांपल देता हूं देखिए एक कोचिंग इंस्टीट्यूट है उस कोचिंग इंस्टीट्यूट में ए बहुत ही फेमस टीचर है ए इज द टीचर इन अ कोचिंग इंस्टीट्यूट एंड बी इज द ऑनर ऑफ द कोचिंग इंस्टीट्यूट बी मालिक है कोचिंग इंस्टीट्यूट के और ए ऑनर है बी ऑनर है एंड ए इज जस्ट अ टीचर ए की वजह से बी की कोचिंग इंस्टीट्यूट में बहुत सारे स्टूडेंट्स आ रहे हैं ए को लगा कि सारे स्टूडेंट्स मेरी वजह से आ रहे हैं लेट मी ओपन माय ऑन कोचिंग इंस्टीट्यूट ए ने बी के कोचिंग इंस्टीट्यूट के बगल में ही एक नया कोचिंग इंस्टीट्यूट ओपन कर लिया एंड ड्यू टू दैट अ लॉट ऑफ स्टूडेंट्स केम फ्रॉम बीस कोचिंग इंस्टीट्यूट टू ए ओके एंड बी को बहुत सारा नुकसान हुआ बहुत सारा मॉनेटरी लॉस हुआ व्हाट हैपेंड हियर देयर इज अ लॉस और डैमेज बी को नुकसान तो हुआ बट क्या बी का कोई लीगल राइट वॉलेट हुआ इज देयर एनी इंजुरिया कैन यू टेल मी इन दीज फैक्ट्स इज देयर एनी इंजुरिया और लीगल इंजरी नॉट एट ऑल देयर इज नो इंजुरिया देयर इज नो लीगल इंजरी हियर ए हैज एक्सरसाइज्ड हिज लीगल राइट ही हैज नॉट वायलेटेड anyone's legal right a ने अपना legal right exercise किया we have a legal right to practice any profession trade or business so a ने वही किया he exercised his legal right he didn't violated the legal right of b so it's a perfect case of damnum sign injuria in which there is a loss but there is no legal injury so here we come to a very important conclusion that injuria is the most essential ingredient for a tortious liability to arise अगर tortious liability arise करानी है then the most important ingredient is injuria and what about damage what about damnum it should not be there or it is irrelevant दोनों में फर्क है अगर इंजूरिया के साथ डैमेज भी हुआ हो तो भी एक्शनेबल होगा रिमेंबर इंजूरिया इज द मोस्ट इंपॉर्टेंट एसेंशियल एंड डैमेज इज इररेलेवेंट इट मींस इट डजंट मैटर डैमेज हो या ना हो फर्क नहीं पड़ता इंजूरिया होना चाहिए okay in law of torts damage may or may not be there, but injuria should always be there. Okay, Raj, you will have the other teachers will give you the schedule of other classes as well. Don't worry. आप इस platform को just subscribe कर दें and hit the bell icon. Whenever there is a class, you will be notified. Okay, so the two foundational principles of tort law: injurious and damnum sine injuria. Injurious and damnum is an actionable tort because there is injuria, although there is no damage. And in damnum sine injuria, it is inactionable. It is despite of the fact that there is damage because there is no injuria. So here we come to the conclusion that injuria is the most important essential of a tort law, of a tortious liability, and the damage doesn't matter. Damage is irrelevant. Remember, इसका मतलब ये नहीं समझना है कि डैमेज नहीं होगा तभी टॉर्चस लाइबिलिटी अराइज होगी, ऐसा नहीं है। डैमेज होगा तो भी टॉर्चस लाइबिलिटी अराइज होगी, डैमेज नहीं होगा तो भी टॉर्चस लाइबिलिटी अराइज होगी अगर लीगल इंजरी हुई है तो, अगर इंजूरिया हुआ है तो। ओके, अ डैमेज विद अ लीगल इंजरी, it is a damage without a legal injury, that's why it is inactionable. But if I will say a damage with a legal injury, then it is actionable because there is a legal injury. So remember, damage is irrelevant. Irrelevant means हुआ है या नहीं हुआ उससे फर्क नहीं पड़ता. Right in bad writing personam is also clear, बहुत important है. Moving to, let me give you a brief intro what is civil wrong and what is public wrong. आपको ये तो पता चल गया है that civil wrong is known as private wrong, which can be the breach of contract, breach of trust or tort, and it can be a crime as well. A crime which is a public wrong because it shows the conscience of the society and society के representatives जो कि स्टेट है वो उसमें प्रोसिक्यूट करते हैं. बट लेट मी गिव यू सम मोर डिफरेंसेस बिटवीन देम between a civil wrong and a private wrong. So guys, first of all, remember civil wrongs are also called private wrongs because these wrongful acts are committed by one individual against another individual. यहाँ पर अगर state भी है तो state is also in its individual capacity, not in its capacity as representative of the society. स्टेट भी अपनी इंडिविजुअल कैपेसिटी में होती है, सोसाइटी के रिप्रेजेंटेटिव की कैपेसिटी में नहीं. एंड द स्टेट हैज नो रोल टू प्ले. That's why state has no role to play. The cases can be A versus B or the state, and but in criminal cases, the cases are always state versus the accused. Clear? Where state represents the society. Criminal cases can be are like state which represents the society versus accused. अगर आप पहले के टाइम में भी देखेंगे, इफ यू हैव हर्ड हिस्ट्री, तो सोसाइटी रॉन्ग डूअर्स को पनिश करती थी, पूरी सोसाइटी मिलकर पनिश करती थी. अब सोसाइटी को रिप्रेजेंट स्टेट कर रही है तो स्टेट पनिश करेगी. इन सिविल केसेस द केसेस आर जस्ट लाइक ए वर्सेस बी. ओके, देन गाइस, another basic difference is that what is the primary remedy. The primary remedy in criminal cases is, first of all remember, यहाँ primary लिखा है, exclusive नहीं. I am talking about the primary remedy, not exclusive remedy. Exclusive मतलब सिर्फ वही नहीं है, but primary remedy है. In civil cases, what is the primary remedy? Compensation, damages. And if you will not pay compensation, then you will be imprisoned. पहले आप पे compensation charge किया जाएगा. You will be asked to pay a compensation of any amount, for instance 50,000 rupees. And if you fail to pay the compensation, then you will be imprisoned. अगर आप compensation pay नहीं करेंगे तो ही आप जेल जाएंगे. So the primary remedy in civil case is compensation. There can be other remedies as well, like imprisonment can also be there in civil cases. I told you in what circumstances. When you do not pay compensation. And in criminal cases, what is the primary remedy? जब कोई crime करता है तो क्या उससे compensation लिया जाता है? Obviously लिया जा सकता है, but the primary remedy is imprisonment. Imprisonment. So the primary remedy in criminal cases is imprisonment, but it is also not the exclusive remedy. In the Indian Penal Code, there are 6 types of punishments, 6 types of remedies, and the 7th one was repealed. 7th थी transportation for life, जब काला पानी की सजा पर अंग्रेज भेज देते थे. Now it is not there. There are 6 types of punishment. Rigorous imprisonment, जिसमें आपको जेल में रखा भी जाता है और आपसे मजदूरी कराई जाती है, पत्थर तोड़वाए जाते हैं. सिंपल imprisonment, you simply have to be in the jail, आपको कोई मजदूरी नहीं करनी है. death penalty, which is known as capital punishment, imprisonment for life, umr kaid, forfeiture of property, and the sixth one is fine, which is compensation. So the primary remedy in criminal law is imprisonment, but the exclusive remedy is not imprisonment. Simply, the primary remedy in civil law is compensation, but not exclusive. प्राइमरीली यही सजा मिलती है सिविल एंड क्रिमिनल केसेस में. आई होप इट इज क्लियर दैट प्राइमरी रेमेडी डिफर करती हैं इन सिविल एंड क्रिमिनल रॉन्ग्स. नाउ the parties to the suit also differs. As I say, that parties to a suit in civil cases are private individuals. The state can either be the plaintiff, the state can either be the defendant, and the state can either be none of the two. But in criminal cases, state is always there as the prosecutor. In the criminal cases, party to the suit is always the state, the representative of the society, and and state can never commit a crime. सरकार कभी crime नहीं कर सकती है, तो state would always be the prosecutor and can never be the accused. So it is also clear that the parties to the suit differ in civil and criminal cases. Moving forward, all civil cases are compoundable. Now, what do you mean by compoundable? सारे civil cases compoundable हैं, while majority of the criminal cases are non-compoundable. Compoundable means compromise is allowed. Out of court settlement जिसे कहता है compromise. इन क्रिमिनल केसेस कॉम्प्रोमाइज इज नॉट अलाउड. अब किसी ए ने बी का मर्डर कर दिया और फिर ए बहुत पैसे वाले हैं, वो बी की फैमिली से कहता है कि आई विल पे यू 50 लाख रुपीज, आप केस वापस ले लीजिए. दे कैन नॉट टेक इट. मींस ये सब इस तरह होता है. आई नो इन प्रैक्टिकल लाइफ पीपल पे मनी एंड देन विटनेस हॉस्टाइल हो जाते हैं. जब विटनेस की गवाही नहीं देंगे, बियॉन्ड एनी रीजनेबल डाउट गिल्ट प्रूव नहीं हुआ, एंड द पर्सन वुड बी एक्विटेड. दैट इज समथिंग डिफरेंट, बट कॉम्प्रोमाइज इज नॉट अलाउड इन क्रिमिनल केसेस. इन सिविल केसेस इट इज अलाउड. ए एंड बी के बीच डिस्प्यूट है, अगर वो केस वापस लेना चाहें बाय कमिंग टू अ कॉम्प्रोमाइज, दे कैन गो फॉर इट. बट इन क्रिमिनल केसेस कॉम्प्रोमाइज इज नॉट अलाउड. क्रिमिनल केसेस कैन बी ऑफ टू टाइप्स, कंपाउंडेबल एंड नॉन कंपाउंडेबल. जो हीनियस ऑफेंसेस होते हैं वो कंपाउंडेबल होते हैं, एंड अ नॉन हीनियस ऑफेंस इज नॉन कंपाउंडेबल. ओके, सो अ क्रिमिनल केस, as I said, yes, coming to the class here, a criminal case can be of two types, compoundable and non-compoundable. Non-compoundable. What is the difference between the two? The compoundable and non-compoundable. In compoundable criminal cases, compromise is allowed. ये बहुत ही minor nature के होते हैं, like defamation. I am giving you an example. Defamation is a compoundable criminal case. ये A versus B के फॉर्मेट में ही चलता है, इसमें स्टेट प्रोसिक्यूट ही नहीं करती. बट इन नॉन कंपाउंडेबल क्रिमिनल केसेस कॉम्प्रोमाइज इज नॉट अलाउड. What is not allowed? Compromise is not allowed. Let me give an example. Murder, rape, जो हीनियस नेचर के क्रिमिनल ऑफेंसेस हैं, दोज आर नॉन कंपाउंडेबल. सो रिमेंबर, सिविल केसेस आर ऑलवेज कंपाउंडेबल. कॉम्प्रोमाइज इज अलाउड. आप कोर्ट में केस फाइल कर चुके हैं, बाद में आपका कॉम्प्रोमाइज हो, आप केस वापस ले सकते हैं. बट इन क्रिमिनल केसेस कॉम्प्रोमाइज इज नॉट अलाउड, बिकॉज सिर्फ आप ही, सिर्फ विक्टिम ही अफेक्ट नहीं हुआ है, पूरी सोसाइटी अफेक्ट हुई है. इफ अ पर्सन हैड बीन रेप्ड, तो सिर्फ वो इंसान अफेक्ट नहीं हुआ, पूरी सोसाइटी अफेक्ट हुई है, एंड सोसाइटी की रिप्रेजेंटेटिव है स्टेट. दैट्स व्हाई इवन इफ द विक्टिम वांट to make the compromise is not allowed legally. The compromise is not allowed. Witness hostile hona and all hona, ये सब these all are practical things which are beyond law. But under law, compromise is not allowed because the state is fighting the case on behalf of the whole society. So remember, there is one more difference. Civil cases are compoundable. Criminal cases are non-compoundable. Okay. Yes, Raj, there would be math classes as well, don't worry. And now coming to some categories of wrongful acts that constitute crime as well as torts. So guys, there are a lot of torts. In the coming class मैं आपको बताऊंगा that there are a lot of torts which are crime as well. And वो tort वो under the law of torts आएंगे या फिर under the law of crimes आएंगे, would be determined by the gravity of the offense. कि gravity कितनी है उस offense की. Like defamation, it can be a tort as well as a crime. Trespass can be a tort as well as a crime. Assault can be a tort as well as a crime. Negligence and nuisance can also be a tort as well as a crime. Now, अब आपके माइंड में होगा सर ये ग्रेविटी क्या है? What is this gravity? Let me explain you with a very basic example. Nuisance का tort ले लेते हैं. All right. A ने एक पब्लिक रोड पर गड्ढा खोदना शुरू किया. He started digging ओके, ही स्टार्टेड डिगिंग, एक गड्ढा खोदा। उसकी वजह से क्या हुआ, बिकॉज ऑफ हिम डिगिंग अ होल, पूरे जो भी लोग उस पब्लिक रोड को यूज करते हैं उनका रोड ब्लॉक हो गया। ओके, द रोड वॉज ब्लॉक। व्हाट इज दिस, अ प्राइवेट न्यूसेंस और अ पब्लिक न्यूसेंस? व्हाट इज दिस, अ क्रिमिनल न्यूसेंस और अ टॉर्ट ऑफ न्यूसेंस? इट इज अ क्रिमिनल न्यूसेंस, इट इज अ पब्लिक न्यूसेंस। यहां पर इन्हें क्या किया, इन्हें पब्लिक रोड को डिग किया, जिसकी वजह से जो भी लोग, जितने भी लोग उस सोसाइटी, उस रोड को यूज करते हैं, उनका रास्ता ब्लॉक हो गया। He committed public nuisance. Public nuisance is criminal nuisance because it's a public wrong, na? If it's a public wrong, then what did A committed? Public nuisance. But वहीं पर B नाम का एक इंडिविजुअल उस गड्ढे में गिर गया। It is the private nuisance. Why? Because यहाँ पर एक स्पेशल डैमेज हुआ है only to a private individual. So एक सिंगल एक्ट से दोनों भी हो सकते हैं। Remember, a civil remedy and a criminal remedy are are not are not interchangeable to each other. Okay, they are corresponding, they can go in a single act. All right, like एक लेडी के साथ रेप हुआ, वो दो केस फाइल कर सकती हैं, द वन फॉर कंपेंसेशन एंड अनदर फॉर अनदर, ऑब्वियसली जो स्टेट लड़ेगी टू पनिश द रॉन्ग डूअर। इट इज क्लियर टू यू? Raj, the telegram channel, I shared the link of the telegram channel in the starting of this session, you can have it. क्लियर? सो न्यूसेंस का जो मैंने आपको एग्जांपल दिया, इसमें मैंने टॉर्ट एंड क्राइम दोनों बता दिया। ए ने जब सड़क पे गड्ढा खोदा जिसकी वजह से पूरी पब्लिक को नुकसान हुआ, पूरी पब्लिक का रोड ब्लॉक हुआ, ऑब्स्ट्रक्ट हुआ, इट इज पब्लिक न्यूसेंस विच इज क्राइम। एंड व्हेन बी नाम का एक पर्टिकुलर इंडिविजुअल उस गड्ढे में गिर गया, इट इज प्राइवेट न्यूसेंस। ओके, बिकॉज सो द स्टेट कैन प्रोसिक्यूट ए फॉर द पब्लिक न्यूसेंस, स्टेट वर्सेस ए होगा, एंड फॉर प्राइवेट न्यूसेंस बी स्पेसिफिकली ए के अगेंस्ट कंपेंसेशन का केस फाइल कर सकता है for the damages caused to him, because it was a special damage caused to a particular individual in addition to all the public, in addition to the one that of occurred to the all public. So guys, with this we come to the end of this class. I hope everything is clear. If anybody has any doubt, any question, you can raise, otherwise I will just end the class. Hi Sakshi. So with this I shall end the class, and happy to see you all here. We will meet again at 9 p.m. in the evening. Till then, bye bye, good luck, and have a great day.